Welcome to my YouTube channel, VaJee Law. Now we are dealing with another amendment in Section 9. Okay. The amendment to Section 9 of Principal Act IBC 2016, introduced by the Insolvency and Bankruptcy Amendment Act 2026. For your purpose of clarification, this amendment is published in official project, but it yet to notified. Okay. Are aimed at streamlining the application process of operational creditor and enforcing the stricter judicial timeline to prevent the admission bottlenecks. Okay. This amendment basically focuses on three things: faster admission timelines, stronger regulatory control, and pre-verified evidence requirements. Okay. Of Section 9(3), Section 9, subsection 3, clause E. It replaces the term prescribed is replaced with specified. Okay, prescribed prescribed generally means refers to rules made by the central government, and specified refers to regulation made by the IBBI. Okay, Insolvency and Bankruptcy Board of India. Why it is important? It shifts the regulatory power to IBBI, allowing faster update to the documentation requirement, and documentation requirement regarding how we are going to record a default and debt, or any other requirement per se. Okay, dynamic adaptation to market practices and the reduction of procedural gap, or to address the emerging procedural hurdles. Okay, this is very crucial for the regulators, because they have the real-time control over the evidentiary standards, making Section 9 filing more efficient and standardized. Okay. 14, as we seen in Section 7, 14 days rule also applicable here, that adjudicating either have to admit that application or reject that application within 14 days, and timelines are also fixed. If there is a multiple application regarding the same corporate data, then the first application will be date of first application treated as the initiation date, and from that initiation date 14 adjudicating authority have 14 days. Okay, what's new uh, here? Again, in 2016, there is a existing of a 14-day mandatory period, but that period is not mandatory. It's directory in nature. Now, with the amendment of 2016, it made directory. Means adjudicating authority have to record a reason for delay. Okay, impact. What is the practical implication of this? It reduces the admission stage backlogs, prevent the indefinite pendency, and to introduce accountability. Yes, how is introducing accountability? Earlier, blame is put on the judiciary that a matter is pending for so long, but nobody specified the reason. It's not necessary there is a delay only the part of adjudicating authority. There is sometimes lawyer are not present. They ask for a passover, and sometimes reply are not timely filed, and sometimes there is structural issues as well. Okay. Next is pre-verified evidence by information utility. While it's not explicitly part of Section 9, these changes must be read alongside the new mandate under Section 215, subsection 3. What it says, operational creditors are not required to authenticate financial information with information utility before filing. Why this is so critical? Evidence are now pre-verified, dispute over debt are minimized, and admission process become faster. So that is strengthening the 14 days timeline only. Okay. This removes the biggest reason for delay, dispute over the existence of debt at the time of admission. Okay. because in section 7 you see now it is clear that if you have a NESL report, then it is sufficient for the existence of debt. Okay, sufficient evidence. So here is the same, but it's given under 100 section 215 subsection 3. Okay, eliminating the admission bottleneck. When you are combining these changes, pre-verified IO records, 14 days mandatory timeline, and written accountabilities for these delays, then the admission bottleneck is being dismantled. Practical outcome. What are the practical outcomes? CRP faster, reduce the litigation at the threshold level, and better recovery prospect for operational creditors. Uniformity across 7, 9, 10. Another key takeaway here is that section 9 is aligned with section 7 and section 10. Okay, same timeline discipline are existing, same accountability framework, and same efficiency expectations. So that there is we reduce delay on a unified manner, in a unified manner. This create a uniform admission regime under IBC, regardless who are initiating the process. Okay, let's summarize section 9 transformation. Regulatory power shifted to IBI by the inserting word specified, and 14 days admission timeline become enforceable. They are no longer the directory in nature, they become mandatory by law, because you have to record a reason if adjudicating authority fail to pass order within 14 days. Okay, IU authentication is strengthening evidence, admission bottlenecks are systematically reduced, and the message is clear. Operational creditors are no longer at the procedural disadvantage, because in IBC evolving into a faster evidence-driven and regulator control system. If you find this breakdown useful, subscribe for more insight on insolvency law. Thanks.